The letter arrived in a crisp white envelope, the HOA's logo embossed in the top left corner, like a stamp of authority. At first glance, it looked like any routine correspondence, a notice about landscaping regulations, or an update on community guidelines. But the moment I unfolded the paper and scanned the bolded words, my stomach tightened. Notice of violation. Pending eviction review. I read it again, slower this time, making sure I wasn't misinterpreting. My name and address were listed correctly. So was my son's, my disabled son. My fingers curled around the paper, knuckles whitening as I took in the absurd justification Karen, our self-appointed HOA queen, had provided. Excessive accommodations, disruption to community aesthetics, and the most ludicrous one, lowering property values. I exhaled slowly, forcing my pulse to steady. This wasn't the first time Karen had overstepped, but it was, without a doubt, the boldest. She'd made her disdain for my son's needs clear in the past. Snide comments about his wheelchair ramp, passive-aggressive emails about our modified driveway. But this was an outright attack. I glanced toward the living room, where my son sat near the window, his eyes fixed on the backyard. He was unaware of the storm brewing outside our walls, his focus instead on the birds that flitted between the trees. He loved this house. It was our sanctuary, built with intention, designed for accessibility. And now, Karen wanted to rip it away from him. She had no idea who she was up against. Setting the letter down with deliberate care, I reached for my phone. This wasn't going to be a simple HOA dispute. This was going to be a battle. And if Karen thought she could bully my son out of his home, she was about to learn just how wrong she was. I wasn't new to HOA politics. When I bought this house 3 years ago, I knew the neighborhood had a homeowners association, but I wasn't concerned. I had dealt with contracts, bylaws, and legal fine print my entire career. None of it intimidated me. What I hadn't accounted for was Karen. Karen was the kind of HOA president who took the role far beyond its intended purpose. Instead of focusing on maintaining the community, she treated it like her personal fiefdom. From the moment we moved in, she found reasons to scrutinize us. At first, there were small things. Emails reminded me that garbage bins needed to be brought in by a certain hour, a note on my door about the approved types of front door decorations. But the real tension began when I started making accessibility modifications for my son. Liam had been born with cerebral palsy, and while he was independent in many ways, he required a wheelchair for mobility. I made sure our home was tailored to his needs. A smooth concrete ramp leading to the front door, widened doorways, a specialized driveway for easier transport. These weren't luxuries. They were necessities. Karen didn't see it that way. She left snarky remarks in community meetings about how our house was standing out too much. She questioned whether the modifications were truly necessary. And when she realized I wasn't interested in her opinion, she started pushing harder, sending compliance requests, hinting that our adjustments violated HOA regulations. Each time, I shut her down with legal documentation proving otherwise. I thought that was the end of it. I assumed she'd back off when she realized I wasn't easily intimidated. I was wrong. The eviction notice proved she was done with passive aggression. This was an outright attack, disguised as concern for the neighborhood's integrity. She wanted us out, and she was willing to twist the rules to make it happen. I looked at the letter again, my lawyer's mind already dissecting it. The phrasing was deliberately vague, relying on subjective complaints rather than any real violations. She had no legal ground to stand on. She just didn't know it yet. A slow, determined calm settled over me. Karen had picked a fight she couldn't win, and I was about to make sure she learned that the hard way. I sat at my desk. The eviction notice spread out in front of me like a challenge waiting to be answered. The wording was almost laughable. Karen had clearly tried to dress it up in formal language, but the intent was obvious. Due to multiple complaints and violations of community standards, your property has been flagged for excessive, unapproved modifications that negatively impact neighborhood aesthetics and property values. As per HOA regulations, a hearing will be scheduled to determine the appropriate course of action, which may include eviction proceedings. It was all nonsense. Excessive modifications? Every adjustment I had made was legally protected, Negative impact on property values? That was a baseless, subjective claim with no legal standing. I could almost picture Karen smirking as she drafted this, convinced that a few official-looking sentences would scare me into compliance. She had no idea she was dealing with a Supreme Court lawyer. A soft rustling sound pulled me from my thoughts. Liam was wheeling himself into my office, his expression curious but cautious. "Mom, everything okay?" I forced a smile, not wanting him to see my anger, just dealing with some HOA nonsense. He frowned. "It's about the ramp again, isn't it?" I hated that he even had to ask. He was 15. He should have been worrying about school, friends, video games, not whether our own neighborhood wanted to push us out. "They're trying something new this time," I admitted, holding up the letter. "But don't worry. They don't have a case." Liam studied me, his eyes sharp. "Karen doesn't know what you do for a living, does she?" A slow grin spread across my face. "No, and I don't plan on telling her just yet." Liam chuckled. "She's in for a surprise." That was an understatement. Folding the letter neatly, I placed it in a folder with all the other paperwork I would need. Karen wanted to play power games? Fine. But she was about to realize that the law wasn't on her side. It was on mine. 2 days later, I walked into the HOA meeting with the letter tucked neatly into my folder. The community center was already half full, with homeowners murmuring among themselves. At the front of the room, Karen sat with an air of authority, her perfectly manicured nails tapping against a stack of papers. She barely looked at me as I took a seat near the front. That was fine. She'd be looking soon enough. "All right, let's get started," Karen announced, her voice carrying the self-importance of someone who thought they were untouchable. "We have a number of agenda items, but before we get to those, I want to address a serious violation of community standards." Her eyes flickered in my direction, lips pursing in faux concern. "As some of you know, we've received multiple complaints regarding a certain property that has undergone excessive, unapproved modifications. These changes negatively impact the uniformity of our neighborhood and could lower property values." I folded my hands calmly on the table. I wasn't going to interrupt her. I wanted her to lay out every bit of her argument before I tore it apart. Karen cleared her throat and continued. "We've done our due diligence, and after reviewing our guidelines, we believe this issue needs to be formally addressed. If a resolution cannot be reached, we may need to take further action, including eviction proceedings." A murmur spread through the room. Some homeowners nodded in agreement, while others exchanged uncertain glances. That was my cue. I stood, adjusting the cuffs of my blazer. "Karen, could you clarify which specific guidelines my property has violated?" Karen blinked at me, caught off guard by my composed tone. As I stated, the modifications were made without proper approval. "That's incorrect." I pulled a document from my folder and held it up. Under the Fair Housing Act and the Americans with Disabilities Act, modifications made to accommodate a disability do not require HOA approval. They are legally protected. Karen's expression faltered, but she recovered quickly. "Well, we've had complaints from multiple homeowners." "Complaints that have no legal bearing," I interrupted smoothly. "Homeowners' personal opinions do not override federal law. My son's accommodations are not optional. Attempting to remove them or threatening eviction because of them is discrimination." Silence fell over the room. Some homeowners shifted uncomfortably, while others suddenly found the floor very interesting. Karen's lips pressed into a thin line. "We'll need to review this further." I smiled, but there was no warmth in it. "You do that, but I strongly suggest you consult a legal professional before proceeding." Karen's eyes narrowed, but she said nothing. The game had begun, and she had no idea just how outmatched she was. Karen may have backed down in the meeting, but I knew better than to assume she'd give up. People like her didn't like being challenged, especially not in front of an audience. So, while she was undoubtedly plotting her next move, I was preparing mine. That night, I spread my legal files across the dining room table, methodically reviewing every document I had. I didn't just want to win this fight. I wanted to make sure Karen and the HOA understood they had stepped into dangerous legal territory. First, I revisited the Fair Housing Act, FHA, and the Americans with Disabilities Act, ADA. Both laws explicitly protected individuals with disabilities from housing discrimination. Any attempt to remove my son's accommodations, or to evict us from making them, was a blatant violation. Next, I pulled out my HOA's own bylaws and regulations. I had read them before, but this time I scrutinized every clause related to property modifications. As expected, nowhere did it state that necessary medical accommodations required HOA approval. Karen had been bluffing. Then came the paper trail. I compiled every interaction I had with the HOA regarding my son's accommodations, every email, every letter, every complaint Karen had filed. I also gathered supporting documentation, medical records proving my son's condition, official ADA and FHA documents that outlined our rights, photographs of our modifications, showing they were well-maintained and in no way disruptive to the community. By the time I finished organizing, I had a solid legal case ready to go. I leaned back in my chair, rubbing my temples. I could take this to court right now if I wanted to, but I had a feeling Karen wasn't done digging herself into a hole. Across the table, Liam wheeled himself closer, glancing at the files. "So are we suing them yet?" he asked, a mischievous glint in his eye. "Not yet," I said with a small smile, "but we're ready when the time comes." Karen had started this fight thinking she had all the power. What she didn't realize was that I wasn't just prepared to defend our home. I was ready to dismantle every weak argument she tried to throw my way. And when the time came, I wouldn't hold back. The next morning, I drafted my response. This wasn't just a casual email or a firm letter. It was a meticulously crafted legal document designed to make Karen and the HOA reconsider their entire approach. I started with the basics, formally acknowledging the eviction notice and making it clear that I was challenging their claims. Then I laid out my case. Violation of federal law. I cited the Fair Housing Act and the Americans with Disabilities Act, emphasizing that attempting to evict us due to legally protected accommodations was a direct act of discrimination, failure to follow due process. Nowhere in the HOA bylaws was there a clause supporting their claims. In fact, their actions were arbitrary, unsupported by any valid regulations. Potential legal consequences. I didn't outright threaten a lawsuit yet. Instead, I carefully suggested that pursuing this matter any further would place the HOA at serious legal risk, including financial penalties. I ended with a clear demand, an immediate withdrawal of the eviction attempt, and a formal acknowledgement that my son's accommodations were lawful and would remain untouched. Satisfied, I printed the letter, signed it with a steady hand, and sent both an official email copy and a certified physical copy to the HOA board. Karen would receive it soon enough. Later that evening, I saw the email notification. Message from HOA President Karen Mitchell. I clicked it open, already expecting a defensive response. "We have received your letter and will take it under advisement. However, the HOA retains a right to enforce community standards. We will be reviewing this matter further and will inform you of our decision shortly." I let out a slow breath. Karen wasn't backing down yet, but her tone had changed. She wasn't as confident. That was a good sign. Liam rolled up beside me, glancing at my screen. "So, did she surrender?" "Not yet," I murmured, "but she's feeling the pressure." He grinned. "I almost feel bad for her." I smirked. "Don't. She brought this on herself." Karen had two options now: back off quietly or escalate. I had a strong suspicion she'd choose the latter. And if she did, I'd be ready. I had expected Karen to back down, or at least attempt to negotiate. Instead, she doubled down. 2 days after I sent my official response, I found another letter taped to my door. This time, it wasn't just from Karen. It was a formal notice from the HOA board. Notice of community hearing. Due to ongoing concerns regarding unapproved modifications and their impact on neighborhood property values, the HOA board has scheduled a hearing to discuss potential further action, including possible fines or property sanctions. Attendance is mandatory. I stared at the paper, my jaw tightening. She was trying to turn this into a public spectacle, an attempt to intimidate me by rallying the other homeowners. It was a classic HOA power move, meant to isolate and pressure residents into submission. Liam, Reading over my shoulder, let out a low whistle. She's really not letting this go, huh? No, I muttered, folding the letter carefully. But neither am I. Karen thought she was cornering me. What she didn't realize was that this hearing was exactly what I wanted, an opportunity to dismantle her argument in front of an audience. I spent the next evening preparing, fine-tuning every point I planned to make. I knew Karen would try to manipulate the discussion, turning it into an emotional appeal rather than a legal one. She'd likely frame me as the difficult homeowner who refused to follow community rules. That meant I needed to control the narrative. I compiled evidence, not just the legal documents I'd already used, but letters from neighbors supporting my modifications, and even property value reports showing that nothing I had done had negatively impacted home prices. When the night of the hearing arrived, I walked into community center with my head held high. The room was packed, a mix of familiar faces, some friendly, some wary. Karen sat at the front, flanked by other board members, her expression smug. She had stacked the deck against me. Too bad for her. I had brought a bigger deck. I took a seat and calmly placed my folder on the table. Karen cleared her throat and gave me a sickly sweet smile. Thank you for coming. Let's begin. I nodded once. Let's. The tension in the room was palpable as Karen shuffled her papers, clearing her throat for dramatic effect. She clearly thought she had the upper hand, but I could already see cracks forming in her confidence. Before we begin, she started, addressing the assembled homeowners, I want to emphasize that this is not a personal attack on any individual. Our goal is simply to uphold the integrity of our neighborhood and ensure that all homeowners are adhering to community standards. I almost laughed at the hypocrisy. Not a personal attack. She had tried to evict my son under a flimsy pretense. Karen glanced at me. Now, regarding the property in question, I raised a hand, cutting her off smoothly. Before you go any further, Karen, I'd like to clarify something for the record. She hesitated, clearly not expecting me to interrupt so early. Of course, she said tight-lipped. I pulled out a copy of my certified legal response and held it up for the room to see. As I've already stated in writing, my home modifications are legally protected under the Fair Housing Act and the Americans with Disabilities Act. That means any action taken against my family for making these modifications could be considered housing discrimination, a federal offense. A murmur spread through the room. Some of the homeowners sat up straighter, exchanging uncertain glances. Karen's expression hardened. We're not challenging the law, but this community has certain aesthetic standards. I didn't let her finish. Actually, Karen, you're challenging the law. By attempting to penalize my family for making necessary accommodations, you are violating federal statutes. And just to be clear, I continued, my voice steady, if this hearing results in any attempt to enforce penalties or eviction, I will have no choice but to file a formal discrimination lawsuit. That got her attention. One of the other HOA board members, an older man named Greg, coughed uncomfortably. Now, let's not escalate things unnecessarily. I agree, I said smoothly, which is why I suggest the board drop this matter before it turns into a legal disaster. Karen's face was practically twitching. There have been complaints, she insisted, her voice growing shrill, from multiple homeowners. I pulled out another document, a report on local property values. Actually, property values in this neighborhood have risen in the past 3 years, including after my modifications. So if you're going to claim my home is harming the neighborhood, I'd love to see your evidence. Karen opened her mouth, then closed it. Silence. The tension shifted. Some homeowners who had previously been nodding along with Karen now looked at her with doubt. Greg sighed. Karen, maybe we should reconsider this. Her jaw tightened, but she knew she had lost. I leaned back, watching her struggle with the realization that she had just publicly embarrassed herself. And I wasn't done yet. Karen's silence was the longest I'd ever heard from her. For a moment, she simply sat there, her nails tapping the table in frustration. The smug confidence she had walked in with had crumbled, replaced by the realization that she had pushed too far. I could see the wheels turning in her head. She was searching for a way out, some last-minute excuse to save face. But there was none. She had backed herself into a corner, And now the entire room knew it. Greg cleared his throat again. Look, I think we've heard enough. There's clearly no legal basis for this hearing to continue. A few other board members nodded in agreement. Karen's grip tightened on her stack of papers, but she said nothing. I decided to drive the point home. For the record, I said, keeping my tone even, I'm prepared to move forward with legal action if any further harassment occurs regarding my son's accommodations. I trust the HOA will take that into consideration moving forward. Greg nodded quickly. Understood. Karen's lips pressed into a thin line. She looked around the room, perhaps hoping for someone to back her up, but the mood had shifted. Homeowners who had once seemed indifferent or supportive of her were now avoiding eye contact. No one wanted to be on the wrong side of a legal battle. The meeting was over. Karen had lost. As I gathered my papers and stood to leave, I caught her staring at me, her expression unreadable. I didn't bother acknowledging her. She wasn't worth another second of my time. Liam was waiting for me outside the community center, scrolling through his phone. The moment he saw my face, he smirked. So did she wave the white flag? I chuckled. Not exactly, but she doesn't have a choice. It's over. Liam nodded, satisfied. Good. We headed home, the night air crisp around us. For the first time since this mess started, I felt a genuine sense of peace. Karen had tried to take everything from us. Our home, our stability, our right to exist in this neighborhood. But she had underestimated the wrong person. And now, she was the one who had something to lose. In the days following the hearing, the silence from the HOA was deafening. No more letters. No more threats. No more ridiculous accusations about neighborhood aesthetics. It was as if Karen had finally realized that she had played a losing hand and decided to fold quietly. I wasn't surprised when an official email arrived from the HOA board a week later. Subject: resolution of recent HOA matter. After careful review, the board has decided to take no further action regarding the property modifications at our address. We acknowledge that the modifications fall under federal protections, and this matter is now considered closed. It was as close to an apology as I was going to get. I forwarded the email to Liam, who responded immediately with a single GIF, a mic drop. I laughed. Exactly. A few days later, I saw Karen in passing while walking to the mailbox. She was watering her meticulously maintained flower bed, her lips pursed in irritation as she caught sight of me. I gave her a polite nod. She didn't return it. Instead, she turned sharply on her heel and stalked back inside, slamming her door behind her. Liam, watching from the porch, grinned. She's really mad, huh? Oh, absolutely, I said, amused. But she knows better than to try anything now. Because here's the thing about people like Karen. They thrive on intimidation, on the assumption that no one will challenge them. The moment they meet someone who knows the law, knows their rights, and refuses to back down, they crumble. We had won, not just for ourselves, but for every family in this neighborhood who might have faced the same discrimination. And if Karen or anyone else ever dared to challenge us again, they'd know exactly who they were dealing with. A Supreme Court lawyer, and a mother who would never stop fighting for her son.